Court, Jackson County District Attorney Brad Smith spoke to the media, and he explained that more charges against the 14-year-old shooter will be forthcoming. They have not yet taken into account the victims who survived the shooting. Here's what he said.
I know there will be additional charges for Colt because we never addressed the other victims. There may be, I cannot say, for Colin until we get the investigation completed.
Joining us now is criminal defense attorney Chandelle Summer. Thank you for taking the time to be with us. Obviously a very difficult story, and now a new development of it with last night the father now facing charges. What does the law say here in Georgia when it comes to parents buying a gun for a child who is under the age of 18?
Well, surprisingly, it is unlawful for a child under the age of 18 to possess a handgun, but there's no law in Georgia that prevents a child under the age of 18 from possessing a rifle or a long gun. So it does not appear that this is a crime for the child to possess the gun. However, what the district attorney's office is most likely considering in bringing these charges is the fact that it was reckless for the father to allow his son to possess the gun, especially after there was this report a year ago that there were online threats that the child was going to blow up the school.
So the law says it's illegal to have a handgun, but then an assault-style rifle, which you would presume is more powerful, can shoot faster, that is not included in that law.
That's absolutely correct, Chris. It is a snafu, if you want to call it that, in the law that children are not allowed to possess handguns, but can in fact possess rifles. And I think that goes to sort of the gun culture, the hunting culture in Georgia, where parents often take their children on hunting trips where they use long guns.
So presumably his attorneys will say, you know, he did nothing illegal by buying this gun for his 14-year-old son. What does the law say about the liability that he could hold because his son went and committed a school shooting?
Well, it was supposedly a gift from the father to the son. At least that's what's been reported in the media. And that's perfectly acceptable. However, the son cannot buy a gun because he's underage. However, I think that possessing the gun is what it's going to all come down to, whether or not he had the right to possess the gun, whether the father should have known that he was going to use the gun to commit the atrocity that occurred at the high school, and if the father knew or had reason to know that the child was going to do that, he certainly acted with reckless disregard. So the involuntary manslaughter charge is very appropriate. The second-degree murder charge, which is the highest charge that's ever been brought against a parent for this type of conduct. Of course, there was recently the Michigan case where two of the parents were convicted of involuntary manslaughter. But second-degree murder, this is new ground to make parents responsible for the conduct of their children. Georgia's statute is very specific that if the death of an individual happens while you allow a cruelty to children to occur, which in this case would be his reckless disregard for allowing his child to possess a firearm and then causing pain to a child, then that is second-degree murder. So we'll have to see how the evidence develops. Quite frankly, it's a slippery slope because of the fact that parents are not always responsible for the conduct of their children. You could leave your keys on your kitchen cabinet and your child could grab your car, go out and kill somebody, and technically you might be considered responsible for that act. So this is a similar situation, but it involves firearms. It involves AR-15s, which are considered assault weapons by a lot of people. And so it's a very controversial type of case. And you're in the middle of, like I said, probably the staunchest gun rights country or county in the country. So it will be very interesting to see how this plays out.
How strong of a case as far as the father's concerned? I heard you, I know you're a criminal defense attorney, so kind of laying out what could be the defense of this slippery slope that plays out, knowing that there are, a legal snafu where it presumably wasn't illegal for him to gift the gun to his son. How strong of a case does the district attorney have?
Well, first of all, you've got to consider the fact that this case technically will be tried in the county where these crimes occurred. So there's going to be very high emotions. No doubt the defense will move for a change of venue and try to get this to a different jurisdiction. But this is national news. Everyone's going to know about it. And emotions will certainly favor the victims. However, at an appellate level or the Supreme Court level, there could be some discernment of the fact that Georgia does not have a law that prevents possession of long arms or rifles by children. And the question is whether or not the father should have known and recklessly disregarded the consequences of giving his son a firearm. Again, it's new territory. This is a case of first impression. And it may be that at a trial court level, emotions will prevail and the father will be convicted. But at an appellate level, they're going to have to look very carefully at the law and discern whether or not this is going to be the precedent moving forward.
And as far as the suspected shooter, the 14-year-old, he's being tried as an adult. What do you make of that decision? Is that something that will stick as we move past perhaps, the very emotionally charged place that we're in since this happened only a couple days ago?
Oh, yes, that will stick. And quite frankly, if they didn't charge him as an adult, then he would be out of jail when he turned 21 because of the fact that he's a juvenile. There's no way they're going to prosecute him as a juvenile. And I'm sorry, I said 21, I meant 18. So that would be 4 short years. They're going to prosecute him as an adult. And the judge was correct that you cannot impose the death penalty on an individual under the age of 18. There's a United States Supreme Court precedent on that. So he will spend likely the rest of his life in prison. It sounds like a very strong case, and I can't imagine that the district attorney will do anything other than charge him with malice murder after having finished the investigation, because it sounds as though it was planned and it was done with malice aforethought.
We heard the district attorney say that there could be more charges against the shooter and his father, just they had not factored in yet those who had been injured but will survive this shooting. What more charges could we see?
Well, you will see likely aggravated assaults against all of the victims that were injured. And I think what is going on is they're going to determine whether or not the injuries were so bad as to cause the district attorney to want to charge additional crimes, such as aggravated battery, where you have a disabling injury. For example, if you no longer have the use of your hand because you were shot in your hand, that's a more serious charge. There could also be deaths that occur from those other injuries. So I think they are waiting to see what the outcome of the injuries are before finishing this up. This likely, if they've got a preliminary hearing in December, they will probably take it to a grand jury after the first of the year. And at that time, they should have completed the investigation and they'll know exactly what they want to charge.
All right, Attorney Chandelle Summer, always great to have you. Thanks for being here.
Thank you, Chris.